Today we will discuss doctrine of constructive notice. See, suppose there is a company, and in that company, when it was incorporated, it was the requirement that memorandum and articles of the association has to be put before the registrar. That is the requirement of section 7 subsection 1a, and these document, articles of association, memorandum of association, are the public document. So the doctrine of constructive notice is basically arises from this concept that the articles of association, if you remember, section 5 says, is the regulation of the management of company. So what would be management of the company, whether how many director would be there, how the voting will done, who will have the authority to bind the company through making contract, etc., are written in the articles of association. So suppose there is a company A, and with this company A, Mr. X want to make a contract, and in this company it was written in the articles of the association that the managing director can only make the contract. Okay, that means the managing director is assigned to bind through the contract with the company, but this person has interacted with the other officers of the company, suppose for sake of simplicity other director, and the contract was signed. When there was a question that whether this was a valid contract or not, the question raised by the company is that as per their articles, the regulation of management, only the managing director, that means the person or the director who is appointed as a managing director, MD, can only make the contract, can only through the contract bind the company, and other director cannot. Now what is the fault of this third person? This third person may say that I was not aware, but if you see that section 10 of the Companies Act, the effect of the memorandum or articles after registration, and there the effect is that as an individual person, individual shareholder made a contract with the company, so section 10 is silent with respect to the third person. But many times I have said you that these documents are the public document, and that's not that just I said it. There is section 399, section 399 of the Companies Act, or if you read section 399 of the Companies Act, it says, and it give the power to any person, or you can say that right to any person, that any person may inspect the document kept by the registrar. And so the section 7 clause 2, that after those documents produced before the registrar, when some person came for incorporation of the company, and as per section 7 subsection 2, that the registrar has to register those documents. Those documents became the public, and any person by paying the fee can see them. The section 399 is saying that. So it's the similar position like we talk about the registration of the property. With respect, when you are going to purchase immovable property to the registrar office, you can find out that this property belong to which person. And here the outsider who was dealing with the company, who want to make the contract with the company, cannot say that he was not aware about it. He was not aware about the articles of the association. Maybe he has not read it. And this is known as constructive notice. The notice means when you provide someone to the information. And the constructive means maybe you have not provided, maybe you have not read that document. Suppose for the examination in the law faculty of Delhi University, there is information. The constructive notice will apply to the student. Whether you have read it or not read it is not material. So similar concept when applied in case of the company is known as doctrine of constructive notice. So the doctrine of constructive notice, you can understand that memorandum of association and articles of the associations are the public document. And any person get access to these documents can see them. So every person who want to deal with the company is deemed to be, deemed means it is legal fiction, maybe actually he has not read it, is deemed to have the notice of the content of memorandum and articles. Generally it is applied to the articles of the association, because in the articles of the association the regulation of management is there. Memorandum is just, it is the place, name, etc. is written, so only that thing. Okay, and so this kind of the presumptive notice is known as the constructive notice. So you can say that according to this doctrine, any person dealing with the company not only to have read the memorandum and article, but also have to understood them properly according to their proper meaning also. Even you cannot say that I have read it, but I have understood it in the another way. Like in the introduction, Limited versus Provincial Bank Limited case, that the bank got the that memorandum, read the object clause, and that gave the power to the company for raising money on issuing of debenture, but has not understood it properly. It may be noted that whether a person actually read them or not, he is in the same position. The company cannot be made liable for the same, and even after the law of estoppel will not allow such person to say that he had no actual notice of the content of the document. But suppose there is a document that filed only for the record and not as a requirement of the articles of the association, for that this doctrine will not apply. So this doctrine, the justification of this doctrine, you can say that otherwise every person dealing with the company will take the excuse that he has not read the content of the articles of the association, memorandum of the association, and so that is not the fault and company will be liable. So despite having the regulation on that particular aspect, and the director has acted otherwise, or the third person has acted otherwise, the company will be liable. So to save the interest of the company, just to make it feasible that whatever written in the articles of the association, only that in that way company may function or company must function, this doctrine is founded. And so the doctrine of constructive notice is for protecting the interest of the shareholder and the company and to managing its affair. Now, it's not that there is no criticism of this document, because for the third person it is harsh sometimes, because even you have read it or not read it, the law will apply against the third person. And so the Palmer, the book written by Palmer, there it says that the principle applies only to the document which affect the powers of the company. To other document or to the internal proceeding it will not apply. And from that, a new doctrine will emerge, but I will not discuss now. Just me discuss some other criticism. Some jurists, some authors say that this is unreal doctrine because the outsider people know the company through its officer. No one going to read the content of the articles of the association that is in so many pages. Or is it possible that before, if some person on behalf of the company approach, suppose you have the brick store or cement store for the cement, and before making them you say that stop me, just give me 2 days, I will go to the registrar office and then I will read the articles of the association that with your company how it would be done. Even the some person are not in that capacity to read and understand. And so there is a criticism also that this is an unusual doctrine as the people know company through its officer and not through its document. People may have acted in the good faith and their money has been applied with the company for the purpose. Suppose there is a person X and he made a contract with the company, but as per the regulation of the company only the managing director can make the contract, and this person who supplied thousands bags of the cement and that has been used by the company for that company the contract is void and company is not responsible to pay. So how harsh is it for the third person? In the Europe, under European Communities Act, there is section 7 of the 1972 and that abrogated this doctrine of the constructive notice. In 1985, provisions of section 9 had been incorporated in section 35 of the Companies Act 1985, English law. These development I am saying is not from India. In India still is there, that's why we are reading, we are discussing. But in India, sometime for giving justice to the third person who acted in good faith, whose money has been used for the company's purpose, the court, you can say, does not take it seriously, or court has devised its exception. And with the time, the exception got the importance. And what is the exception of the constructive notice? The exception is actually only for the internal proceeding. Suppose in that example that I have gave, that only the managing director can make the contract. But whether that managing director has been actually, authoritatively appointed, or with that there is some problem, outsider cannot know. And even this information outsider will not find in the memorandum or articles of the association. In the articles of the association, it is written that there would be one, managing director and he has the authority. And some director is, purporting that he is the managing director. So whether that person has been duly appointed as a managing director or not is the internal matter. And for that, the company's door are closed for the outsider. This information is not, available in the public domain. And this information even cannot be get through the section 399. So The exception of the constructive notice is the doctrine of the indoor management, and in the court to do the justice with its interpretation to show that whether that particular circumstances would fall under the indoor management or not. Otherwise, still the constructive notice doctrine is applicable in India. So what is this doctrine of indoor management? This is the next issue today. The doctrine of indoor management, as I said, indoor means that is not open for outsider. Management means any fact, any question that is related to the management. And so the indoor management means, in the articles of the association is also the rules of management, but that are outside, or you can say outdoor, available, or accessible for general public. So suppose in the same example I want to come back, that managing director will bind, this is the also the regulation, this is one of the management, that how company will do its business. But whether that person has been duly appointed or not, this is also the question of management, but this is not available in the public domain. So as per the doctrine of indoor management, you can say the doctrine of indoor management constitute an exception to the principle of the constructive notice, or as a rescue step for the outsider. According to this doctrine, the outsider dealing with the company are entitled to assume that as far as the internal proceeding of the company are concerned, everything has been regularly done. That means if there is any flaw with respect to the internal proceeding, then outsider must not know, and so uske according that everything has been done. So if a person is purported to show as a director that he is the managing director, in that question it's not that whether that person was not actually managing director will act against the outsider, but it would act in favor of the outsider. But suppose any other person as a fraud, even not having the director, is showing him the director, in that case that is the fraud, that would not apply against the company. Okay, and so in other words, they can presume that the internal working of the company is in consonance with the provisions of the public document. This means that even if there is irregularity in the internal proceedings of the transaction made by him with the company are enforceable by him on the basis of doctrine of indoor management. The rule of constructive notice is confined to the external position of the company, and therefore it follows that there is no notice as to the law as to how the company's internal proceeding is handled by its. Now, what is the rationale behind the indoor management? The rationale is that the doctrine is based on public convenience and justice. Because as I said, that doctrine of constructive notice is unreasonably harsh to the third person. That I said because third persons deal with the officers of the company not through its document. They know the company through the officers. And so the doctrine of indoor management is based on justice and convenience. The detail of internal proceedings are not open to the public inspection as per section 399 also, and so for that purpose presuming that the outsider even know would be even much harsh, and an outsider is presumed to know the constitution of company but not what may or may not have been taken place within the doors that are closed for the outsider. So maybe suppose there is a company, and in that company the one director has been appointed, and that director has not been duly appointed but he is working. So how we expect that outsider even also know that these were the three formalities according to which this has to be appointed, when he is purporting, he is showing him as a director. And so that is the rescue of the constructive notice based on justice and convenience. Now guys, there is important judgment on this doctrine of indoor management, or you can say that the doctrine of indoor management came from this particular judgment. And the name of this case is Royal British Bank versus Turquand, 1856, 6 E and B 327. I just sharing the screen also so that you can watch it. And many time question is asked, and question is asked with the name that in light of Royal British Bank versus Turquand, define the exception of constructive notice or doctrine of constructive notice. Or sometime the question is would ask like what is constructive notice, and discuss the exception to the constructive notice in light of Royal British Bank. Sometime question is asked like that what is Turquand rule. So this Turquand written here in the name of this case Royal British Bank versus Turquand. This Turquand rule also means the doctrine of indoor management. So whether someone asks as an exception to indoor constructive notice, or indoor management, or Turquand rule, in all these three situations you have to write about the doctrine of doctrine of indoor management and this judgment Royal British Bank versus Turquand. It's very classical judgment. Now see, in this case the company's article provided that director may borrow on bonds such sum as may be from time to time authorized by the resolution passed at a general meeting of the company. So as per the articles of association, the power is given to the director that director may borrow. And when director are borrowing, that means that bind the company also. Director may borrow on behalf of the company. How much amount? For that, there it was not provided. It was saying that as per, the general meeting decided, to that limit the director may borrow. Okay. So this particular was the one of the management rule provided in the articles of association. In fact, in the internal proceeding, no resolution was ever passed. So there was no resolution passed, and so it was difficult because power is given, but how much they can borrow, for that there is no resolution, and this would lead to the controversy. What happened that at one point of time director needed some money for the company. So the directors of company borrowed a sum of money from the plaintiff, the Royal British Bank. They have borrowed the money. Okay. And from the Royal British Bank, they borrowed the money on a bond bearing the seal of the company also. When the Royal British Bank asked for repayment, the shareholder contended that company shall not be bound by this particular bond. Why? The reason they are giving that yes, the directors are empowered under the articles of the association but how much amount that has to be as decided by the resolution passed in the General Assembly. But with respect to this limit, there was no resolution ever passed. And so in that light, the same has not been, director has not been authorized to borrow this much money or kuch bhi money, whatever the amount. So directors are not authorized. It was, however, in the case when it come to the question, this this resolution, whether passed or not passed in that behalf, was not available in the public domain. One has to presume only the constructive notice of that document that is available in the public document. And whatever the information available in the public domain, that director may borrow from time to time as authorized by the resolution passed at a general meeting of the company. And so outsider is with the bona fide intention that yes, there was some some resolution, and that's why director are borrowing this much of money. So the director or the outsider, for the outsider, there is the presumption that whatever the regular proceeding is actually has been completed. Whether it has been completed or not is not, because that would injustice toward the outsider. Here the Royal British Bank has provided the money to the company through its director. Director borrowed the money, that was on the seal, the director was saying. So there is not even the iota of the doubt that the director does not have the authority. Even if you talk about, or if you see the articles of association, there also it has been written that director may borrow the money, kitna money, as from the time to time authorized by the resolution. So actually that resolution has been passed or has not been passed, that is not something for that also the constructive notice can be imposed. Because this much of the information, that whether resolution has been passed or not, is the internal matter or the internal proceeding of the company, for which doors are closed for the outsider. And so for that constructive notice should not apply, and the doctrine of indoor management should come for the rescue. Here also the court in this case held that the bank, the Royal British Bank, need not to inquire that whether the internal formality of the passing of resolution in the General Assembly was actually made or not. It was the matter of internal proceeding. It was the matter of internal management. The company was held to be liable by importing that this is the matter for which the outsider have no access, and so doctrine of indoor management will apply as an exception to the constructive notice, and so in that case constructive notice will not be applicable. Lord Hathley observed that outsiders are bound to know the external position of the company, but are not bound to know the internal management if the directors have the power and authority to bind the company, but certain preliminaries are required to be done before the exercise of such power. The person contracting with director is not bound to see that all such preliminaries have been observed. Now if you read this case there, the